Good morning, sir. Am I audible, sir?
Good morning. Good morning.
Thank you very much for coming to address us. I'm
Pleasure
Thomas
is mine.
Sal,
Pleasure is
Chairman.
mine. Pleasure is mine. At least give me the opportunity to meet with you, interact with you once again. Coal India was my client as when I was ASC, I used to advise them in some matters. I appeared also for Coal India also.
Sir.
So when Mr. Sarangi requested me, I felt that would be very good. Initially, I thought to try to avoid because I'm not a good speaker. I can't speak.
Yes, sir. How can I not speak?
No, you give me a brief, then I can speak. But without a brief, as a lawyer, I can't say anything. You give me a brief, then I can speak.
Yes, Sarangi sir. So you are still holding the court through e-system, electronic system, or?
No, both are running simultaneously. If both party agrees, they can appear physically.
नहीं वो जज साहब आ गए हैं। आइए नहीं। हाँ जज साहब हैं। अच्छा सॉरी 11:30 पर है। नहीं जज साहब तो इसको अब तो बात करें। हाँ हाँ हम पर है भाई हमसे बात कर रहे हैं। आपका नंबर है उनका?
Yes, I can hear. You can also hear me, I believe. So why to 11:30, sir? We are scheduled at 11:30, I believe.
Okay, I'm sorry then, sir. I thought कि
No,
since you are
it's no difficulty, no difficulty, no difficulty. No difficulty. You are busy otherwise. You are busy otherwise. I am sitting here. I have no occasion. So you can
sir, plan at 11:30, sir.
Right. Thank you so much.
नमस्कार सर।
नमस्कार. इसको स्विच ऑफ करो।
आवाज है कि सर वीडियो फ्रीज हो रहा है थोड़ा। हेलो सर। हाँ हाँ अभी ठीक है कि सर वीडियो फ्रीज ठीक है सर। ऑडियो ठीक है बट वीडियो हल्का सा फ्रीज हो रहा है। वीडियो क्या हो रहा है सर? वीडियो फ्रीज हो रहा है। फ्रीज हो रहा है थोड़ा पीछे में सर बैकग्राउंड में फैन चल रहा है क्या? फैन का आवाज आ रहा है। वो ठीक नहीं है वीडियो फ्रीज हो रहा है सर। नहीं आपका आपका ही जा रहा है सर। आपका नेटवर्क स्लो है। सौरभ आपको मिल गया आपका नेटवर्क स्लो है।
सर हेलो, मेरा आवाज आ रहा है सर?
हाँ आ रही ये
आप मेरा माइक ऑफ मत करिएगा सर वहां से। मैं ठीक है सर।
ठीक सौरभ मेरा ऑडियो वीडियो क्लियर है सर।
थोड़ा सा कोई फैन चल रहा है क्या? फैन का आवाज आ रहा है, ऐसा लग रहा है मेरे को।
अभी देखो हेलो।
हाँ अभी ठीक है, अभी क्लियर है। अभी क्लियर है एकदम। हाँ अभी क्लियर हो गया, ठीक है।
अभी बोल सौरभ थोड़ा।
हाँ हेलो, माइक में आवाज आ रहा है मेरा?
हाँ ठीक है। इको नहीं आ रहा ना?
आ रहा है, मेरे को भी आ रहा है। नहीं ये कोई अभी नहीं आ रहा, वो फैन का थोड़ा नॉइज था, वो चला गया।
अभी जो वही कंप्लेन पे अच्छे करने को हुआ वैसे उसको करने का या वो कहते हैं कि क्या करते हैं वहाँ वो भेज रहे हैं कि भाई वो रहा था ठीक है तो ये भी पढ़ाई करिए जो भी मैं उसको इन मत और ये मत और नहीं
Good morning, Sarangi sir.
Good morning, sir.
Good morning. Let's start.
Okay. Um, uh, His Lordship is visible. He's on line. लाइन में है क्या?
Can you hear me?
लाइन में है सर.
लाइन sir. Yes.
Yes.
Good morning to all of the audience. They are eager to listen to His Lordship, Sri Kausik Chanda. Sir, our chairman is also attending the meeting. Before we start, I will give a very short introduction to His Lordship. He was born in 74. He was a law graduate from Calcutta University in 1997, enrolled as advocate in 1998, and he was designated as a senior advocate in 2014, appointed as ASG in 2015, and elevated to the bench in 2019. So Chandra is a very simple soul. I had to persuade His Lordship quite extensively to come and agree to share his ideas on this Vigilance Awareness Week. As you know, sir, today the Sardar Patel's death anniversary. Around that, every year birth anniversary. Every year we observe a Vigilance Awareness Week. Basically, this year's motto is Vigilant India and Prosperous India. Satark Bharat, Samridh Bharat. So we invite eminent speakers from different walks of life, from academics, from judiciary, from business fraternity also, to enlighten us with their point of view. So without wasting much time, I would request His Lordship, Sri Kausik Chanda, to deliver his address to us. Thank you, sir.
Good morning. Thank you, Mr. Sarangi. I'm privileged to have the opportunity to interact with you all on the occasion of observing the Vigilance Awareness Week of this year. Mr. Sarangi, when requested me to speak on the issue, I told him that I would request one of my brother judges to deliver a speech on the topic. But Mr. Sarangi insisted that I should say something to you regarding the vigilance awareness, since I have had some experience of dealing corruption cases of many government departments. I was asked to narrate 2 or 3 cases on how corruption adversely affected public interest and national prosperity. One more area I have been asked to touch is how government departments are found to be generally lax in pursuing legal matters once a case is filed in court, either due to ignorance or other reasons. Why do government people often lose in a legal matter? To start with, I fondly recollect last year when I was elevated as a judge. Mr. Sarangi, you can also recollect, you were also there.
Yes,
A small gathering of about 5 to 6 officers was organized by your organization. The then chairman of the Coal India Limited jokingly asked Mr. Sarangi whether throwing such a party would attract vigilance proceedings. I feel today it's first necessary to appreciate what we understand by vigilance angle. I had the occasion to hold brief on behalf of Chief Vigilance Commissioner in the writ proceedings during my stint as Additional Solicitor General, when I was shown the vigilance manual where the word vigilance angle was explained. An employee of Bose Institute complained corruption in appointment of retired personnel at Bose Institute. He was incidentally the then registrar of the Bose Institute, and departmental proceedings was pending against him on the alleged issue of some sexual harassment of an employee. So, a complaint at his instance, and it was a whistleblower complaint. If a complaint while exposing a case of corruption, complainant while exposing a case of corruption, wants his identity to be kept secret, he can lodge a complaint under Public Interest Disclosure and Protection of Informers Resolution, popularly known as whistleblower provisions. The Commission is mandated not only to maintain the secrecy of the complainant's identity,
but also provide protection to the complainant against any physical threat, harassment, or victimization. But on his complaint, neither the Central Vigilance Commission nor the Central Vigilance Officer of the Post Institute took any steps. He came before the High Court by filing a writ petition and saying that CAG found that the authorities allowed the extension of tenure of various personnel without requisite approval or of the appropriate persons. He said management of the institute are guilty of draining public money by such wrong appointments. The persons in management and the control of the Post Institute, therefore, are guilty of causing loss to the state exchequer by granting appointments on irregular basis to the retired employees. The CV ought to have been taken appropriate steps on the complaint. The proceedings ought to have been initiated against the persons involved. Now, the question arose before the High Court whether it is a vigilance case or not. Now, the vigilance manual, it defines what is vigilance angle. Vigilance angle is obvious in the acts like demanding or accepting gratification for using influence, or for obtaining valuable things from a person with whom he has official dealings, or obtaining for himself or any other person any valuable thing or pecuniary advantage by corrupt or illegal means, or by abusing position as a public servant. It may be possession of assets disproportionate to the known source of the income. And the cases of misappropriation, forgery, or cheating, or other similar criminal offense, those are also vigilance cases. But other cases where the cases like gross or willful negligence, recklessness in decision making, blatant violation of systems and procedures, exercise of discretion in excess, where no ostensible public interest is evident, failure to keep the controlling authority or superior informed of the required transactions in time. These are the sum of the irregularities where the disciplinary authority, with the help of the CBO, should carefully study the case and weigh the circumstances to come to a conclusion whether there is a reasonable ground to doubt the integrity of the officer. In this case, when he made allegations against the managers and against the authorities of the Post Institute that they blatantly violated the rules, regulations in appointing some retired persons, High Court observed that the blatant violation of systems and the procedure by itself does not tantamount to existence of a vigilance. The same has to be coupled with something more for the action to qualify as a vigilance action. In the fact of the case, the CBU and the CBC, upon consideration of the materials before them, came to a finding that vigilance angle was not available. And accordingly, High Court dismissed the case. The next, I would like to narrate a case related to Prevention of Corruption Act. The fact of the case is that, in that case, an officer of Indian Railway was an IRTS officer, Indian Railway Traffic Service officer. While he was serving as a Deputy Chief Operation Manager, Freight Operations Information System, he tendered his resignation. A clearance from vigilance was necessary prior to acceptance of the resignation of the railway officer. The General Manager of the Southeastern Railway intimated the Railway Board that no vigilance and special police inquiry was pending against him. The requested the board acceptance of the resignation of that officer. The Railway Board intimated the General Manager that the President of Railway Board accepted the resignation of the officer with effect from 2007, subject to payment of all outstanding dues. The General Manager, South Indian Eastern Railway, however, did not release the petitioner from the service for undisclosed. In such circumstances, the officer wanted to withdraw his resignation. His prayer for withdrawal of resignation was refused, and the service of the petitioners terminated with immediate effect. So having tendered his resignation from service, the petitioner was not entitled to any pension. More than 4 years after the officer tendered his resignation, an FIR was lodged against that officer, his wife, and brother-in-law under the Prevention of Corruption. The FIR was lodged on the basis of an oral information received by the CBI on suspected offence of possession of assets disproportionate to his known source of income and abatement of the said offence by his wife and brother-in-law. The FIR said that the officer, while posted and functioning, indulged in various corrupt practices and acquired huge disproportionate assets in excess of 9 crores by corrupt and illegal means. The CBI alleged that he obtained illegal gratification and extended undue favor to some parties at the time of allotment of rakes under the Wagon investment scheme in the Southeastern Railway. The officer used NOC in favor of one company, which was a logistic company, and was not eligible for participation in the Wagon investment scheme. The officer submitted his resignation in the wake of investigation conducted by the Village Branch, the Southeastern Railway, on receipt of a complaint from one of the applicants. The FIR of the CBI further alleged the officer didn't own a property till the year 2005-6. But he disclosed that his wife had purchased a flat in February 2006 at a cost of rupees 35 lakhs. He didn't intimate the source of finance for the purchase of the same flat. He became the managing director of a company, and the balance sheet of the same company reflected total assets of the company in excess of rupees 19 crores. The officer and his wife held huge amount of equity shares of the state company at total face value more than 5 crores. He invested his ill-gotten money in the various companies where his wife and brother-in-law are directors. He also incurred huge expenses on his personal foreign travel while he was posted and working in Southeastern Railway. He parked part of his ill-gotten money abroad during the aforesaid foreign trips. He invested his ill-gotten wealth after retirement in a clever manner to camouflage the same as his purported income from business. He declared a very nominal income while he was in service and drawing salary from the railways. But subsequent to the acceptance of resignation, he declared income of rupees 30 lakhs for the year 2019, financial year 2019, and a staggering amount of rupees in excess of 2.5 crores for the year 2010 and 11. It was alleged that while he was in service, his wife was a housewife and his brother-in-law was a student. The case of the officer before the court was that the railway board has accepted the resignation of the officer only after getting clearance that no vigilance and square inquiry was pending against him. Even after acceptance of resignation, the railway authorities illegally and arbitrarily didn't release him from service, and he was ultimately released. With regard to the issuance of NOC in favor of a logistic company under the Wagon investment scheme, the officer said that a logistic company was not barred from participation in the Wagon investment scheme. He further made out the case that he was not the allotting authority of the rates, and he was merely processing the officer concerned with the application submitted before the authority. The applications were recommended by the senior officers and thereafter approved by the railway board. As regards the illegal allegation regarding acquisition of flat in the name of his wife, he said that the flat was purchased taking loan from the bank. On the date of purchase of the same flat, the officer had enough money in his bank account and earned by him as a salary as well as a savings. Now, the High Court held in the case that the general rule of criminal justice is that crime never dies. In offences of this nature, prosecution is launched by the authority, and the court ought not to throw out the prosecution solely on the ground of bail. The object of criminal law is to punish the preparators of the crime. In this case, you can recollect that after his retirement, after his resignation, after 4 years, the case was started against him. The court observed that the astronomical figures reflected in the bank account or in the income tax return of the individual do not necessarily imply that the same has been earned by illegal means. The officer, after tendering his resignation, joined business. He made good use of his service experience for the development of business. More so, his business concerned with the railways. Any diligent businessman will make use of his optimum resources to maximize his profit margin. It may happen that the officer may have utilized his earlier contracts for growth and development of his business. It may also happen that due to the acquaintance of the officer with the railway officers, the officers did good business and earned huge returns. But at the same time, the High Court observed the possibility of being involved in illegal activities during the service period cannot be ruled out completely. The time taken by the officer to develop several multi-crore business after resignation from service is so short that it leads to presumption of misconduct. The allegations are extremely serious, and the CBI authority ought to have conducted a thorough preliminary inquiry to verify the information received from its source and ascertain whether there was any misconduct on the part of the officer when he was in service. Lodging the FIR solely relying on the source information without conducting a preliminary inquiry was held to be bad in law and contrary to the provisions of Act and CBI Manual. The High Court directed the CBI to conduct a preliminary inquiry to verify the allegations made in the source information report. The petitioner was directed to cooperate with CBI in course of the inquiry. Since there was allegation of stacking huge sum of money in India as well as foreign countries, the CBI was directed to take necessary steps in accordance with law to ensure that the alleged ill-gotten wealth is not used in money laundering or in any other illegal activity. This case shows that the bureaucracy has the opportunities to deal with a variety of state lodgings in the form of contracts, licenses, and grants, giving them a wide discretion which can lure them to wealth and property. For prevention of corruption and connected matters, subsequent to the enactment of Prevention of Corruption Act 1947, many new acts have been enacted with the object of dealing with the circumstances, contingencies, and shortcomings which are noticed in fighting against corruption. The laws relating to prevention of corruption were essentially made to deal with economic offences. The conduct of the petitioner who was in the Indian Railway Traffic Service officer would have attracted at least 3 acts, namely Prevention of Money Laundering Act, the Prohibition of Benami Property Transaction Act, and Black Money Act, if the same offences had been committed today. First act that would have attracted it's the Prevention of Money Laundering Act 2002. The PMLA Act is administered by the Enforcement Director. They are empowered to attach the property purchased with the proceeds of crime and prosecute the offender who deals with proceeds of crime. The railway officers, all bank account, property, and shares could have been attached by the Enforcement Director under the PMLA. The provisions are stringent. If the officer was arrested by the Enforcement Directorate level, it would have been extremely difficult for him to get a bail from the court. The bail provision in the Act is similar to the NDPS Act, which deals with the narcotic cases. I have seen in some of the chit fund cases in West Bengal are being conducted by the CBI pursuant to the Supreme Court order. The Enforcement Directorate is also investigating into some chit fund cases. Rose Valley cases where the amount involved is huge is being investigated by the Enforcement Directorate. They have done a commendable job. A large sum of money has been identified and attached. The Calcutta High Court is contemplating disbursement of such amount to the poor investors by selling out the attached properties and releasing the money which is lying in the bank account of the company. The officer could have been dealt with under the Black Money Act also. In the full form of the act is the Black Money, Undisclosed Foreign Income and Assets and Imposition of Tax 2015. Recognizing the limitations of the existing legislation, the central government introduced a new legislation to deal with the undisclosed assets and income stashed away abroad, which legitimately belong to our country, to the nation. The Supreme Court of India has also expressed its concern about the issue. The assessing officer under the provision of the Act would have made an assessment as to the undisclosed foreign income and asset and direct payment of penalty in addition to the tax, a sum payable equal to 3 times. That officer could have been punished with rigorous imprisonment up to 7 years. The proceedings against the officer could have been initiated under the Benami Transaction Prohibition Act also for holding the property in the benam of his wife and brother-in-law. This act is being implemented again by income tax officers. While the property is not purchased from a disclosed source of income, the authorities on the land are empowered to attach the property and prosecute the offence. Now, I must draw your attention to another aspect of the case. You might have noticed that before the High Court, the case was filed in the year 2012 for quashing the FIR. That officer approached the High Court in the year 2012. And the case was ultimately decided in the year 2019. Which means, even after filing the FIR, it took at least 7 years to start the proceedings against the officer. And that is only because of the pendency of the case before the High Court. He got 7 years of time. And no one could proceed against him in spite of such allegation of corruption pending against him. And there is a specific provision in the Prevention of Corruption Act that if any case is filed challenging a proceedings under PC Act, no court would grant stay of the proceedings. The delay in disposal of the case before a court of law is only. But you need to understand that the court is a battlefield. And the government before the court is a litigant like any other litigant. It doesn't enjoy any special status. To win a battle, you need to hire good soldiers led by a good commander. You need to fix your strategy. Government as a litigant in most cases turns out to be a very weak party, a very weak litigant. CBI has a branch that deals with the banking fraud cases. Some smart people mortgaging the same property obtain loans from different banks, or they otherwise fraudulently obtain bank loans never to repay. I had the occasion to deal with some of the banking fraud cases when I was ASG. And to my surprise, I found that in some cases, the amount involved were more than 100 crores. CBI diligently investigates into the case and files charge sheet. But when the trial starts, it takes years to conclude the trial. The delinquents, they obtain bail, and thereafter they go on filing applications for traveling abroad with their families. These types of applications seeking permission to travel abroad, I found were not diligently or properly contested by the CBI or the trial court. And if sometimes the trial court doesn't grant permission, they come to High Court and obtain order. Once I asked CBI officers why these people visit foreign countries so frequently. One of the officers replied, it is probably due to ensure that the siphon money is properly invested. So they drag the case for years, enjoy life, go for regular foreign trips with their families. All they need to do is to ensure that the criminal case pending against him does not reach this logical conclusion. The government litigation mechanism, sorry to say, lacks professionalism and efficiency. Because I have had the experience. I dealt with the government cases for more than 10 years, I can say 10 years. The government officials are sometimes reluctant as the outcome of the case doesn't affect their career. Some government officials take keen interest in conducting litigation, but ultimately find that they can't do little because of the various restraint in government procedure. A private party conducts and pursues litigation for its self-interest, which is conspicuously absent when the government is a litigant. Sometimes you need to hire good professionals paying proper fees, which may not always be permissible for a government official in spite of his intention to engage a good professional, good lawyer, a renowned lawyer. If a private litigant suffers an adverse order, his lawyer has a liberty to prefer appeal immediately within 24 hours. For government, it's a prolonged procedure. By the time government decides to prefer an appeal when it suffers an adverse order, the appeal becomes time bound under the Limitation Act. A private lawyer thinks if he can give relief to his client, he can not only charge fees from his client, that client will fetch in another client. His career is performance based. But an independent government lawyer doesn't know when his fees will be paid. He can, however, ensure flow updates by pleasing a law officer easily rather than working out a brief by burning midnight oil. If proper assistance is not rendered by a government lawyer to the judge, how one can expect not to suffer an adverse order? So, in spite of many legislation being in place, a corrupt citizen remains unpunished using the shortcomings of a judicial process. I would conclude today by indicating another aspect of vigilance proceedings. We have no difficulty in understanding vigilance angle. But the tricky part is when the definition, by definition, the vigilance angle extends to a case where an officer, without having an ill motive or taking any undue favor, can be dragged to a vigilance proceedings for a wrong decision. Every higher authority vested with administrative power needs to use his discretion in decision making. He is not expected to follow a straitjacket formula in every case. A departure from the prescribed norms may sometimes be necessary to serve the best interest of the organization. Ideally, the fear of vigilance will stand in the way of an officer who uses his discretionary power for the interest of the organization. It may reduce the managerial efficiency. The risk taking may result loss to the organization. But every loss should not and does not impede a vigilance employee. An honest officer must work without fear of. We hope that exercise of discretion should be judicious, free from any personal agenda or gain, and for the personal interest. And not for the personal interest, but for the public interest. I thank you all for giving me the opportunity to interact with you. And I expect that India and all, as a proud Indian, we are looking forward to corruption is not. Thank you.
Thank you, His Lordship, Sri Kausik Chanda, on behalf of All India Fraternity, on behalf of our respected chairman, and on behalf of all the officers who are tuned in to listen to you. And you have beautifully described what is vigilance angle and dissected into its various nuances. The cases that you described are also very interesting. Those who have been listening to the speeches, they can find the fine line between what actually happens in judiciary and executive and the kind of proof and evidences that they require, the loopholes and getaways for the corrupt to escape the system also. he also told about the various set of laws that exist in the country and how sometimes they are at loggerhead with each other, such as PMLA, Prevention of Money Laundering Act 2002, Prevention of Corruption Act 1988 with its subsequent modification in 2018, and there are other things. There are many times the Prevention of Money Laundering Act, which has a very strict bail clause, is doesn't come into effect unless a case is lodged, because it's a predicate offense. Unless the premier investigative agency files a case or an FIR, the ED doesn't take up that case, and therefore the person in other set of laws where it is easy to get bail and difficult to attach property finds a very providential, rather opportunistic escape. So this, we are really thankful, sir. You spared your valuable time in this difficult corona period, and speaking from your home. Sir is also the second youngest judge in the Calcutta High Court, rather one of the youngest, I think, in the history or something like that. Maybe the top 5 youngest judges in the history of Calcutta High Court. Once again, I express our deep sense of gratitude and thankfulness to you, sir, for you to agree to share the
Thank you,
message.
Mr. Thank you. Thank you, Mr.
Thank you, sir.
Thank you, Mr. Manmohan. Thank you. Thank you.
One minute.
फिर 15-20 मिनट 20-25 मिनट बोला ये यहाँ कोई लड़का था ना ये वीडियो हेलो हाँ हेलो ऑफ करने के लिए बोल दीजिए चैनल का दिख रहा है